Okay, so we will get ourselves started. So just again, a little bit of housekeeping while people are joining us. If you're new to the whole Zoom experience, the best way to watch a presentation like this is to do it on speaker view. To do that, you'll change it. It's either in your top left or top right. Usually it'll say either speaker view or presenter view or panel view or something like that. You make sure it says speaker view, and when you know you're there, it's just me. You see just me speaking in your biggest frame. The other little bit of housekeeping is, because we're going to keep you muted throughout the whole presentation, as I mentioned before, just so that it's clear for us to be able to hear each other, you will be able to chat with us through the presentation. So the way that you're going to do that, if you have a question specifically that you would like me to ask, then you'll go to the chat, which is on the bottom row. You'll click on it, and then you'll chat to Linda. Linda's going to be moderating those chats and asking the questions at the end if I haven't already asked them. And if you have any comments that you want to go out to everybody, feel free. Also, there might be a poll at one point that we're going to ask you a question. When we send out the poll, you usually have about 30 seconds to respond. Please do. It'll be a simple poll, and it'll just give us an idea of where we're at in your knowledge area. Okay, people are still coming in, but I think what we'll do is we'll get you started. All right, so I'm going to introduce to you our guest. Our guest today is Catherine Fournier. As a West Island, Catherine has always wanted to be part of our community by helping out people around her. As such, she decided to become a notary, which gives her the opportunity to meet many different people and to help them with their legal needs. Graduated in 2009, she has over 10 years of experience with all aspects of notarial field, including drafting wills and protecting mandates. She has developed over these years a very good relationship with her clients because she takes the time to understand their particular situation. She listens and she makes sure that they receive the appropriate guidance. Her approach makes sure that all her clients get a proper information that's adapted to their particular needs and to be able to give them the best legal advice required in whatever the situation is. I am very proud and very honored to introduce to you Catherine Fournier.
Hello.
Welcome, Catherine.
Thank you.
So we're just going to jump on in, and I have a ton of questions, some that have been coming into us prior to Zoom, and others that, as I mentioned earlier, will come in throughout the whole conversation.
Okay.
All right, so we have about an hour together, and let's start us off. So what is the difference between a notary and a lawyer in the duties that you do?
Okay. So basically, the notaries and lawyers, we start off on the same grounds, meaning that we all go to law school together. So we all know each other from somewhere. What happens once you graduate law school is, because in Quebec it is based on the Napoleon system, which comes from France, we're the only province who offers either the opportunity to become a lawyer, which means that you will then be called to the Quebec bar and as such become a lawyer, or you will get the master's degree in law, with the specific concentration of notarial work, and at which point you then become a notary. Our difference is that I'm a lawyer that doesn't go to court. So if you have problems and you want to sue someone, I'm not the best person to call. I'm not allowed to present in court. I am, however, allowed to give legal opinions. I touch on a various subjects, so I'm able to give a legal opinion, but I'm not able to represent parties. And as notaries, we're also independent legal advisors. So we don't take sides. We basically apply the law. This is what it says, and this is what we do.
Oh, great.
So that's the
So,
main.
in other words, if I'm a person who likes to fight it out and debate it out, I become a lawyer. And if I'm kind of person who likes to talk it out and understand my clients, I become a notary.
Yeah, something like that. What we do is we're here to help. You know, we do a whole array of things. But if those of you who've done wills or bought a house, you know that the notary is there representing both parties and basically applying whatever contracts were written out. And as soon as, let's say, you're not happy and you want to, let's say, sue your seller that's selling you the house, then we tell you we can't help you. That's not our role. We're also what we call public officers of the law. So we are, our governing body is the government has authority over it. So all of our laws and our guidelines are all coming from the government. So that's why we are allowed automatically to be commissioner of oath. We can celebrate weddings, marriages, the ceremonies without having to get the authorizations to do that. So that's pretty much
That's
basic of that.
Extremely clear. So today our topic is estate planning.
Yes.
Can you give us an outline of what's involved in estate planning?
So usually when we sit with clients to discuss estate planning, the two major things that we touch on, there's a lot of other things that come from it, but the two major things will be talking about the will and then talking about the protective mandate, who used to be called the mandate in case of incapacity, which includes the power of attorney, the living will, all of that stuff. So those are the main 2 points when people sit with us that we would discuss on. Depending on the law is so general and everybody has a specific situation. So we would also add on certain things if you are, let's say you're not married and you own a house together, and what do we do? Or your common law owns a house, we can do cohabitation agreements. Some people want to get married, we also execute prenups. That's all what we do in the estate planning, but generally mostly will be wills and mandates that we'll discuss.
Okay, at this point, I'm actually going to try to launch the poll. And if you could just take a second, those of you who are watching, and just try to answer the poll for us. Just waiting on Natalie to get that going. Nat, can you launch the poll, please?
It has been launched and people have answered. So the question, have you a notarized will or testament? Avez-vous un testament notarié? 61% of the people have answered yes, and 39% have answered no.
Okay, thank you very much. It's interesting because I actually look up the statistics in Quebec, and I was kind of shocked to find out that over 50%, I think it's 52% of Quebecers have never done a will and testament. And it's good to know that the supporters and the participants of the Cancer Wellness Center are above the average.
Yes.
I always knew they were, but it's good to know that officially. So, I think one of the things that it's most interesting that I hear from people about when they're doing wills and testaments is the idea of, well, I'm not rich. I don't have an estate per se. So why would I even consider doing a will?
Yeah, the nature of the will, and that's a common misconception that we have with our clients who are coming in, is that, well, I don't have anything, or I just have my house, or I'm married, or my husband. That's kind of the wrong question to be asking. The reason that you are making a will is to protect whatever assets you do have, but also to facilitate in the execution of whatever needs to be done through your estate. even if you don't own a house, you own investment accounts, you have bank accounts, there's always something that we own. And should we not have a will, you have to then revert back to the civil code. Now, the civil code, we're lucky, it's properly organized. It gives certain powers, but it's so limited in what you're allowed to do that it ends up costing you more in the end to not have a will. The simple reason is we got to do what we call a declaration of heredity. So we have to go in and who will be the beneficiaries of the estate. Then you guys got to come up with an executor, but then you're very limited with the powers that you're allowed to do as an executor. So the main reason that we want to do our will is to make sure that whoever we're leaving our assets to, our families, our loved ones, our friends, they're not stuck with the complications of being restricted to executing a will as per the civil code, which is a very restrictive. You would think you'd be allowed to, oh, I'm just going to invest the money. You're not allowed to do that. Safe and sound investments, very limited. Oh, we're going to sell that. No, I'm sorry, you can't. We need everybody to agree on it because the civil code doesn't allow you. And the worst one is if your children are under 18 and you did not make a will. Yes, your children will inherit, but as soon as a minor inherits over $25,000, we now have to create what we call a family council. We need court authorization to be able to act, move the money, invest the money. So you end up being stuck in a very, very strong, heavy procedure that would be otherwise non-existent if you had a will. So that's the main reason. Don't care how many assets you have. We just need to know whatever you have, we need to be able to transfer it properly. And I've seen so many estates where people would come in and say, well, my uncle died, he had $5,000. We're not able to get it out of the bank. No, I know. We have to do these steps and this is how much it's going to cost you. And it's almost $5,000. So they don't even bother to do it because it's the price of whatever is the estate is more than whatever you would receive. So it's really to facilitate. That's why the will is so important. Just, you don't want to revert back to the law. It's not going to be your friend if somebody passed away.
And I guess also, when we're grieving, to have to walk through this process and be confronted with all the many, many, many obstacles and paperwork that happens after after the death of a loved one.
Absolutely.
To have this on top of that would be just, probably incredibly overwhelming.
There was a study that was done that you can look into that, but they were saying that the families of loved one who passed away who had a will, it helped their grieving process because it meant that the person who passed away, they valued whoever they wanted to leave their assets to. Okay, it's part of the grieving process to say, well, they cared enough, they did a will, and it makes me sometimes angry when I have these conversations. They say, I don't care, I'm going to be dead, they can fight it out. But once we're gone, and it's the people that we leave behind that we need to know, what did you want? How did you want this to happen? And especially those of you who have big families. It becomes interesting to manage dynamics during those estates. So
yeah, I remember when I was young, my grandmother took me by the hand and she walked me around her house and she gave me and my brother little stickers. And she said, I want you to go around the house and put your sticker on what you want when you die. Yep. And I remember being absolutely horrified by this experience. And then, of course, we got used to it and started putting stickers on absolutely everything. And my brother ended up putting a sticker on my grandmother, which I thought was pretty adorable. But is there a way that we could, sort of pre-plan everything and write it all out and actually never have to go to a notary or just go to a notary for a signature? Or is there a process to make this, I guess, simpler?
So I know some people, I've heard that a lot also. If I make a will, that means I'm going to die. And I keep telling my people as a joke that I have a very good success rate. Very few of my clients have passed away in the past 10 years. So, you know, we're good. It'll be fine. I already on my sixth will change. So, you know, you could do it on your own. So the way that the civil code is done is that it says there's a couple of ways to liquidate the estate. The first one is if you don't have a will, this is how we go about it. You're also allowed to have a will that's a handwritten will. So we call a holograph will, which is fine. You're allowed to do that. This kind of will is very delicate because it does need to go through probate. So it's not automatically recognized. So we got to get in a specialist to attest that your signature or that your writing was your own handwriting. Because if you have your neighbor write out your will and you sign it, doesn't work. So it's a very, you have to write it yourself. It has to be clear enough that we understand. But then again, you're writing it yourself. So a lot of the elements that we need to liquidate a will be absent from that will. Unless you're a notary handwriting your own will, there may be a lot of blanks, and what happens is whatever blanks there is in that will, it gets filled in by the civil code. It's not because you have a will that, oh, automatically it's okay and we get all the whatever's missing. Civil code. Can also do a will, type it up, have witnesses come in, which is similar to what a lawyer would do as a will. Again, they're not bad wills. I'd rather see someone have a handwritten will or will before witnesses than no wills at all. But again, there's the whole concept of getting it probated, which means that we find your will, the official will needs to be the original. We need to find the witnesses, make them sign affidavits, but then we have to open documents at the court, okay? There's delays, there's bigger costs, and for those unfortunate people who were doing this during COVID, they were pulling their hairs out because the courthouse was closed for some time. So we weren't able to, you know, get anything going. We had to request emergency hearings just to open files and stuff like that. So, and then what happens is it also exposes you to the will being contested. Now, anything can be contested. I'm not happy, anything, you know, whether it's your handwritten will, the will before witnesses, the will before notaries. The thing is that once you do your will before a notary, you come into the office, I make sure that my main three things that I have to make sure is that you are who you are, that you are capable and competent of understanding, and that you're basically signing of your own free will, which is why we also have a witness come in to attest to these things. If you're signing your will handwritten or in front of a witness, there's no guarantee that somebody else didn't force you to write this will. And so that, in certain cases, has opened up lawsuits, and the will or the estate, it gets tangled up into all of these court procedures and can be open for years because it, you know, either it wasn't written properly or they're contesting or no, she didn't mean that. Especially those of you who are thinking of disinheriting family members. Don't do it handwritten. It's the worst because that's where a lot of the problems will arise with those kinds of wills. Whereas in front of a notary, they're not that you can't contest them, but they're extremely difficult to contest because they're going to have to call me to court, and they're going to have to put in my authority as a public officer of the law, and you're going to have to prove, because the notarial deed has the highest value in court of any document that you could ever write. So you're going to have to prove that I was in on it, that I forced you to sign it, that there was collusion, that you was. So it's very difficult. Not that it can't happen, but it's hard. So that's why we always tell people, I'd rather you have a will, but if you are going to have a will in Quebec, you should be having the notarial will, because that's the only one that will guarantee a limited exposure to any people contesting. And also it's the only one that doesn't require a probate. No court fees, no nothing. You come in, someone's passed away, we get the proof of death, do a will search, we have it, and off you go. So
let's wheel back this conversation a little bit, and let's say I'm walking into your office for the first time. I have no idea what's involved in estate planning.
Mm-hmm.
Can you walk me through this process, Catherine?
Yeah. Usually what we do is we sit with the clients an hour, even more, and I ask the questions. It's kind of like going to the doctors, but more fun. So I ask you, I want to know what you have. Who are you planning on leaving it to? How? So, and then once we know, okay, what it is that you have, well, how is this person? You want to leave it to your grandkids? Perfect. How old are they? Do you want your kids to inherit the money right away if they're 18? Some people, they have a lot of money and they say, well, I want to give it to my kids. Well, how old are they? 22 and 23. Do you want them to walk away with $500,000 upon your death? It seems like a big party to me. So those are the kind of questions. So we walk people through, and a lot of people feel the pressure to have all the answers right away. It's not how that works. Usually the first appointment will be to know what your family situation is or what situation you have in your estate and determine the best way for you how to organize it. So you don't need to have any of the answers. You only need a social insurance number. That's pretty much the only ID that you need to bring. And then we go through it with you step by step, with regards to assets. And we'll look at every single asset that you have and how it is that you want it to be distributed through your estate.
And there's some terminologies that you probably would be asking us that maybe you can give us a little bit of clarity on. For example, what does power of attorney mean?
Okay, so the main thing, so in the will, the main names that you're going to hear us say a lot, or the terms, will be the liquidator. So the liquidator is the executor. So in Quebec, we know since 94, we no longer use the term executor. It's still around, but your will never refer to an executor. It's an obsolete term. So the liquidator, the executor, that's the person that's going to be in charge of your estate. That's the person, that's the what we call it, the leader of the band, okay? The one in front who says, this is what we're going to do once you've passed away with your assets, and communicating with banks and insurance companies. And so that's liquidator. We're also going to ask you about a legatee. So a legatee will be who is the beneficiary of your estate, okay? Who are you going to name to inherit? Usually at this question, there's also subcategories, because most people will come in, they say, I did my homework. If I pass away, it goes to my mom, and then it goes to my kids, and I go, well, what if all of you pass away at the same time? So that's what we call the disaster scenario. There's no better way to put it, but so those are again the terms that we will be using. For the mandate, so the power of attorney, it will be who will be in charge of your affair. Did you want me to talk about that separately after, maybe, because there's a whole for the power of attorney? I would like to
put it aside and
put it aside for now, because I want to get into that and have like the whole explanation of that perhaps once we're done with the wills.
Perfect. So once I've come in and I've sort of decided who's going to what was the word? It's not
the liquidator.
Not the executor, the liquidator.
The liquidator.
I had it down as executor, so thank you for that.
Liquidator.
As the liquidator, can I refuse
Absolutely.
to be a liquidator?
Yeah. The first thing we will be discussing when we talk about the wills and we talk about your liquidator, the most important for us, and we see this a lot, is, well, I want to put my 5 children together. Great. However, that's a lot of people to liquidate an estate, right? If you want to put all 5 of them together, that means that all 5 people need to be there at the same time to sign, to make decisions, to sign checks, to go to the banks, to sell the property. It's heavy, okay? We don't discourage it, but we try to explain to you a little bit of the downside to naming too many people. And then we have the other types of people that say, well, I'm going to name my eldest. Problem with your eldest is he lives in California and he's an artist and he's not super good with money. He doesn't understand Quebec law. He doesn't understand finances. And quite honestly, he doesn't really care. We love your eldest, but we're going to need someone else there. And I always tell people, I'm the youngest in the family, and guess who got named on everybody's wills as the executor? Maybe if I wasn't a notary, but still, so we try to tell them, and I also tell them a little bit as a joke, you don't want to be the executor. It has to be the toughest job ever. It's very, very tough. You have to be thorough. You have to go through all the banks. You have to do the paperwork. You have to speak to the accountants. You need to do it properly. And then in the background, you're going to have your siblings and all the beneficiaries. When is it done? Where's this? Where's the money? Where's that? It's a very ungrateful job to be the executor. So you want to find the best person possible, someone who understands, filing income tax, someone who has the capacity to be able to take on administration, ideally someone that's organized, because there's a lot of paperwork and there's a lot of steps to go through. So that's where we discuss with the clients the best possible liquidator for you. May not be the 5 together, may not be your eldest, but will be someone, that has the capacity and that will be able to do that. And also I remind them that whoever you name, while liquidating the estate, if it's your children, they're also going to be grieving. So you want the best possible person there, because it's extremely emotional to go through your parents' assets and things and liquidating. So you could name 2 if they're close enough and they're able to work together. That's not a bad idea, but we usually recommend, 1 executor, someone that's going to be able to, lead the ship is what we want.
And I guess it would be incredibly important to ask the person before you put them in your will, if they're willing and will accept it.
We usually ask them to notify them, but you are always allowed to renounce. So we touch that. You're allowed to say no. This is why in our wills, we're going to ask you to name more than 1 executor or liquidator. Who's your first one? Who's the first person? And then if he can't do it, or he's out of country, or he's unable to do it, who's your second? So I usually ask people to come in with at least 2 to 3 names of executors, so that we're not stuck, that we have options in case one of them refuses.
So what happens if I've done my will in my 30s and really didn't even look back at it again? And then when I died, my liquidator is actually died as well. And I don't have a second person. What happens?
So what happens is whoever will be the legatees, the universal legatees of your estate, which are called the beneficiaries, they will come in and they will have to decide amongst themselves who will be the executor. So it's not, you never get stuck, because the wills that we draft will provide for this. Number 1, number 2, number 3, what if they all refuse? Then who's going to be in charge? And then if there ain't nobody there, we go to the courts and we ask a judge. We say, we want to name this person, we need a judgment, he'll be the executor. Those are in rare cases where there is nobody. We also touch on,
it doesn't have to be a family member. It could be a best friend. It could it be a notary as well?
It could be. You'd have to check. We need to ask if that notary is willing to take it on. We're usually really reluctant in being named in wills. We are able to assist clients either by getting a power of attorney and taking on the full liquidation of the estate, or just helping you out with certain things depending on the complexity of your assets. Okay. Sometimes people are able to do it's like we close a bank account, we'll transfer the house and the RRSPs, and we see the accountant. You don't need to pay me for that. But we've had some estates where a lot of the beneficiaries, they were all in Europe, and there was money all over the place and properties all over the place. Those become more complex for one person to. So usually we either do it with an accountant who's qualified to be able to help out and find all the assets and do the proper tax papers.
Okay, because one of the questions that's coming in the chat is, well, what if you have no one? What do you do?
If you have no one, usually you speak to your bank. That's a good option. Some people want to name their accountants. That's fine. You need to ask them if they're willing to take that on. Some accounting firms agree. We've had that happen, lawyers, accountants, but sometimes we tell people, you know what, probably the best for you is if you're alone here and all of your family, you know, lives in Europe, or you have no family and you want to leave it to whatever charities or whatnot, perhaps it would be best for you if you went to your bank and you spoke to their estate department and have them name as your executor, so that way they can take on the liquidation of the estate and making sure that the assets are going to be distributed properly, the taxes are going to be done. So all of the big major banks, they all have that service that you can request.
Okay, perfect. When I went to do my will, one of the questions I was asked was, how much money do you want to gift to your liquidator?
Yep.
So I guess that's done. And is it an average amount that you usually gift to the liquidator for doing the tasks?
There's no average amount. It depends on the size of your estate. It depends on the complexity of your estate. Usually, also, we have to be careful. Some people say, I want you to be my executor and I'm going to give you $50,000. You have to be important of the amount that we're giving, because the job of a liquidator is not being a beneficiary. So or a legatee in Quebec, you don't get taxed when you inherit. But when you're an executor, they consider it work, and whatever you receive as being the executor has to be added on to your income tax. So we have to be careful, because we don't want people jumping tax brackets because you decided to put $50,000 for them to be the executor. So we've got to be careful about what we're giving them. But you know, usually standard, you know, most of our estates, a house, a car, you know, investments, $2,000 a year, depending on how long it takes to liquidate the estate. Usually you're looking to a year and a half, maybe, depending on how quickly the government would answer. So, but the goal is to not deplete the estate either, right? So.
Right. And if I'm a liquidator and I have to come to your office to talk to you about some issues, am I to always come alone, or can I also bring like a trusted family member with me?
You can bring whoever you want.
Okay, perfect.
It doesn't matter.
Question from the chat.
Yeah, what we try to do when you're an executor, you can come with whoever you want. The only time that we ask, or the way that I do it, is when somebody's passed away. I don't want to meet the spouses on the first meeting. I want to meet the immediate family. I want to see what the dynamic is, and I want to see what's going to come of this. Okay, but if you're the executor and you come with whoever, and you have questions, and we're able to guide you in the right direction and guide you to the proper people as well to help you out.
Okay, perfect. Before, you had mentioned that you know, there's also the opportunity to gift some of your assets to either charities or people outside of your family. Can you talk to us just a little bit about that? Like, how does one decide to, or how does one write up a charity that they want to give to?
So the first thing is always whatever charity you want to gift to, you should speak to them first to see if there's any kind of forms or any kind of specific wording that they require. Come to the office and we have it. I just received the Book of Canadian Charities. Just received my new one. So that's in there, and there's a whole bunch of charities, and they're the, you know, the addresses and the websites and what needs to be done. So that's the first thing, is really, if you're willing, for example, to donate to a palliative care or to a hospital, we need to make sure, you know, is there something specific? We do write it up in the will, and then speak to an accountant also. Sometimes it's a good idea to do charitable gifts through the estate for various tax reasons.
For tax reasons, right?
Yeah,
Because
exactly.
there is a little benefit
Yeah,
when you give to a charity, because you do receive that charitable, the
the
family or the
receipt.
estate receives that charitable tax receipt.
Yeah, exactly. So depending on the, well, maybe not the size of the estate, but just the most important is to make sure that we are designating the charity properly, but that can be done. And you know, to touch on gifts and wills, a lot of people will show up with their list. I want to give 100,000 to this person and 500 to this person. And then I tell them, well, you know, that's great, but what if you need all of that money? What if you pass away? You don't have $500,000, but you just gifted $1 million to all of these people. So when we are doing estate planning, we always tell people to make sure that they are preparing themselves in terms of a percentage of the estate. Because if you pass away and it's worth $1 million, then it's fine. But if you pass away and it's worth 20,000, it's easier for us to distribute a percentage than to try to reconvert it. Oh, when she did the will, she was worth this much, and this is what she meant, and this is how much it is. And so you know, the simpler, the better in a will. I know some people are very controlling and they want to give, you know, 1% every year and then increase if they graduated school. And we have to think in terms of the fluidity and how easy it is to liquidate the estate, because every time that you have more complex clauses, or the more complex your will is, the more time and complexity it's going to take to liquidate. So
Yeah,
we try
absolutely.
to keep it
So
simple.
if I was a TV producer, I would stop this conversation now and I would insert a commercial, and that commercial would say something like, if you would like to put the West Island Cancer Wellness Center in your will, please do. All you need to do is go to our website and you will see that we have a downloadable form. You print that form, you fill it in, and you bring it to your notary, and it's as easy as that. End commercial now. Back to Catherine. All right, so I'm just looking at the questions here, and there's a question, what do you do basically if you don't have a spouse or children? How do you distribute it in your will? How does that work?
Whoever you want. Again, charities, whoever you can give to, whoever. And what's beautiful about being in Quebec as opposed to, let's say, being in France, is that you can leave money to whoever you want. You don't have to leave it to your spouse. You don't have to leave it to your kids. You don't have to, you know, so whoever you want. If you like your neighbor and you say they've been helping me out, they can receive the money. Usually what's going to be important when you're gifting, and let's say you don't have family members, is we want to be as specific as possible. So we're going to need addresses. You can't just say, I would like to leave it to the lovely lady at the Tim Hortons. Like, we need her name and her address, because we're going to need to find her at some point. So, but you're allowed to gift to whoever you want, whoever. There's no restrictions. The only restrictions we have on gifts is you can't say, I'm going to leave it to my daughter. If she gets divorced, then she can get the money. You're not allowed to attach those kinds of conditions to. We wish we could. You can't control it that much.
Good to know. So if my son doesn't get a job by the age of 30, I can't put a condition in like that? Okay, good to know.
Sorry. We have to think in terms of, like, once you gave it, it's gifted. There existed many years ago, there existed a mechanism where you said, I'm going to give it to my husband, and then once he's done, it's going to go back to my kids or to my sister or whatnot. And this was a great concept when it came out. But if you go back 30, 40 years, life was much simpler. Assets were not as scattered. Internet was not there. You used to go to the bank and you knew your banker, and so life was not as complicated. So we were able to trace the money. These kinds of clauses, they still exist, but we don't do them anymore just because we can't trace the money anymore. Like, once it's gone, it's gone. You know, some people now, it's a numbered accounts and this and that. So try to keep it simple. We want to make sure also that people are not going to be more angry at you because you passed away and you did a will and it's very complicated. Because I've had that also. I've had kids swearing at their parents up and down. Why did you do that? Why is it so complicated? I'm like, I'm sorry. So, yeah.
Okay, so another question that came in. What if you want to give everything to your children? What do you have to give to your husband legally? Or can you just not give him anything?
So you're allowed to not give him anything. However, if you are married, so the estate, before we're able to distribute to your children whatever they're going to inherit, we need to make an inventory of your assets and your liabilities. And unfortunately, in your liabilities, you left nothing to your husband. We have to liquidate family patrimony and matrimonial regime. So if you're the spouse who had the most money and you've died, unfortunately, the estate's going to have to pay off the dad before the kids inherit. And that's, let me tell you right now, is a very, very interesting liquidation. It becomes very awkward, okay? Because depending on how close the family is, but I've had that as well, and it's very awkward. But the husband is allowed to inherit whatever the spouse. However, if the surviving spouse has more money, they have to give money back to the estate, because that's like, they're allowed to receive that money. So we try not to do that in wills, or try to minimize it as much as possible, because the family patrimony and the matrimonial regime, they fall into the liabilities of the estate. And so even if you leave nothing to your spouse, they're still allowed to get something. So for those of you who have been separated for 20 years, please get a divorce. So that way there is none of that.
That's an excellent point. And what if the debt that's in the estate is huge? Who's responsible for the debt?
So what happens is we have 6 months to accept or refuse the estate. Okay, the law tells you got 6 months. So in those 6 months, you need to get your will search done, go through the paperwork, and then we do assets and liabilities. If the estate has $100,000 in assets but owes $800,000 in liabilities, we then have to strongly recommend to renounce to the estate. Okay, that's something that you can do, something that's done in front of a notary. So the way it works is that you come into the office, you have your statements, we have you renounce to the estate, we give you the little letter, you mail it to Revenue Quebec, and Revenue Quebec takes care of finding the creditors and trying to pay off some of the debts for the estate. Okay, so you're not bound, because if you decide to accept an estate that has a lot of debts, as the beneficiary of the estate, you're liable to pay all of the debts. Okay,
and it would be important to renounce it.
And you have to make sure that when you go see your notary to do that, you need to come in with all of the facts, because once you've renounced, you can't cancel your renunciation. And then what happens is, if there's an immovable property, never a good idea to renounce. Okay, there's always going to be some sort of a value in the house to be able to sell it. So that's something that needs to be looked at very carefully. Yeah.
Got it. So basically, just to summarize the last 45 minutes, it's a really good thing to get out to do your will and testament, because if not, you might be paying more, or the family or the estate might be paying more after your loved one has passed away. And you can name absolutely anybody as your legitimator, is that the word?
Legatee.
Legatee.
Beneficiary.
I like executor better, for the record. So you can name whoever. It doesn't have to be a family
and your
member.
liquidator.
It could be a friend. It could be a professional. And you don't have to gift anything to your family if you don't want to. But if you are married, then it will automatically go through that process first.
Yeah. We have certain pointers for clients too. I've had some people with difficult relationship with certain children, or if we're unevenly splitting the estate. And what I do is I ask them to write a letter or to write an explanation, because it's part of grieving. You know, you may have a favorite child, you may not want to do it equally, but once you're drafting your will, it's important for you guys to know that you're doing this for other people to be able to grieve properly and move on properly, and also for your assets not to end up with the government for X amount of time. Yeah.
Right. I think, Catherine, that's a beautiful point that you're making, because I love how you keep referring to the fact that you're so aware of the fact that people are grieving through this process. And it does absolutely complicate things.
Yeah, it's very difficult. And as much as we want to be strong, and I mean, I've had to liquidate both my grandmother's estates, and I was very close to them, and I said, I'm a notary, I can do this. I deal with, people hate me at a party because I keep talking about death like it's just a second nature, but I talk about it in terms of, I'm so important that you get your will, you got to do it, blah, blah, blah. And I didn't think it was going to be this hard, but it's extremely hard, even as a professional for me, to be able to contact the banks and to, get the accountants going. And then you're dealing with all my aunts and uncles, and everybody's kind of crying and all over the place. And I'm trying to be strong, but I'm also grieving. So, and this is my job, right? So I can only imagine, my clients having to go through this and grieving. It's extremely difficult.
Yeah. So I'm gonna shift gears a little bit on you, and I'm gonna ask you to talk a little bit about two things: power of attorney and medical proxy.
So the power of attorney mandate, or what we call it, the protective mandate, is one whole document that has two sections. Okay, so section number one. So first of all, this document is used in the event that you're no longer able to act on your behalf. Okay, but there's a lot of nuances in that document, and in my opinion, it is one of the most important documents you can ever draft. So important. Because the nature of this document says that you can only sign it once you are sound of mind and capable of signing it. And I can't even tell you how many phone calls I get a week. My mom's in the hospital, she's in, intensive care. My dad is this, my dad is that, or can you come and sign the power of attorney? And I'm like, well, can we speak to them? Is it, no, they're in a coma, but they can do an X and I just need power of attorney. Ça marche pas. This document, you have to be able to be sound of mind to sign it. Okay, and that document is the document that you're going to name someone to take care of you in case you can't take care of yourself. The will is pretty straightforward. Like you're no longer there, so t'es pas là, we see it. But if you become, if you have Alzheimer's, or if you have some sort of a stroke, or something happens and you're no longer able to speak, or you're limited mobility and anything like that, who's going to make those decisions for you if you're no longer able to make them yourself? You want to make sure you're naming someone good, someone that's going to take care of you, that's going to make those decisions. So in that document, there's two sections. There's the power of attorney section. So the power of attorney is used for the management of your assets. If you need to be in long-term care facility or wherever, who's going to sign the lease in your name? Who's going to speak to the government? Who's going to keep paying your taxes? Who's going to pay your bills? Who's going to have to sell your home or your car? Who's going to need to make repairs? Who needs to go to the bank to withdraw money so you can get clothes, or charitable donations, or if you're giving money to your grandkids every month? Who's going to have the power to continue doing that, because you can't do it yourself? You don't know what you're doing. So that's in the power of attorney. And then the second portion is for for your person. Okay, who do I want to make the best decisions medically for me? Who's going to be meeting my doctors, reviewing my charts, knowing what kind of medication I need? If I need, a minor procedure, who's going to be making that decision? And then inside that mandate portion, there's a clause that's called the living will. And that will be your DNR, pull the plug, call it what you want. That's found inside of there. So it's such an important document, such a complete, it's about 12, 13 pages long. People say, Catherine, it's heavy. It's a lot of stuff in there. Yes, because again, once you're dead, it's fine. We know what to do. You can't generate any more income. We got to cash everything in because you can't move forward. But with the power of attorney mandate, you're still alive. You're still moving forward. Your investments are still generating interest. You still got to pay income tax, or all of these things are ongoing. So that's the most important document. In that document, you're allowed to name, again, how many people you want. But if you name 3 people, they all have to be there. They all have to act together. And again, you need to name the best possible person, someone that would be close by, that's able to speak to the doctors or speak to the banks. Or so. Such an important document.
So I guess as you do for your liquidator, you sort of have liquidator number 1, liquidator number 2. If liquidator number 1 isn't present or can't or renounces, it would be the same thing for the power of attorney.
Absolutely. And in this case, you can have 2 separate people representing you. You're allowed to say, well, my son, he's really good with the finances. He can be my power of attorney. But you know what? I'm afraid I'm going to cough and he's going to pull the plug, or that he's not so present to make those decisions. So therefore, maybe my daughter would be better to make those medical decisions for me. So you're allowed to split up the tasks.
And can your liquidator be also the person who has power of attorney?
Ideally, that's how we would create it, okay? Because some people have been, incapacitated for 5 years. So for 5 years, someone's taking care of their finances, then they pass away. We find out the liquidator is some other person. Like so we usually recommend whoever you name, not as the person making your medical decisions, but whoever's your attorney for your finances and your assets. It's a good idea that they're the same person as your executor. So that way they know, and there's that, it's fluid in terms of asset management.
Okay, perfect. Okay, so I'm getting a few questions that are getting thrown at me here. And so I'm just gonna ask them, so they're in no necessary order, okay? When can a liquidator obtain, or where can a liquidator obtain like a guidebook to help them with the process?
Good question. The guidebook there's a lot of different websites that you can help. We're here obviously to also assist. So we're probably one of the best, but some people, limited budget, or they don't want to pay, or they don't want to make the appointment. There's Revenue Quebec has on the Quebec provincial side, they have a good guideline of what needs to be done in terms of, they're probably the only ones I would trust, because you need to send them money and you need to send them income tax and stuff like that, so they will tell you.
Perfect. So if a couple has a home in both their names and one passes away, can he or she leave their share of the home to an adult child and give the spouse usufruct? I'm not sure. That's it. Of the home? Yes. And you might want to explain the definition of that word, because I actually had to look it up myself.
So what we can do sometimes, and we see it a lot also with families that have children from previous unions that come together later in life, you're allowed to leave the house to whoever you want, your share of the house. But what we would do is we create a right of use. So the we call it a right of use. So in the will, we would specifically state, leaving the house to my kids, but my spouse has the right of use to the house, which means that upon your death, we have to do what we call a declaration of transmission on the property. This is a document that comes in and says, they own the house, they passed away, here's the executor, here's the will, here's what it says. If there is a right of use created in the will, it gets created in that document and it gets registered against the house. Now the children, you may say, they're just going to sell the house. They can't do it. If there is a right of use created in the will, it has to be reproduced in the declaration of transmission, which is registered against the house. And the only way you can remove the right of use is by either signing like a bank, like a discharge, saying, I don't want to live in the house anymore, I renounce to my right, or by producing the death certificate of the person that had the right of use. Because the right of use is not perpetual and it doesn't get gifted to other people. It's specific for one person and it lasts until they decide to leave or until they pass away themselves.
Okay, thank you. One of the last questions that has been asked is, if I was to come to you or any other notary to support in creating my will and testament, and which included my power of attorney and my medical proxy, how much is that going to cost me?
A basic fee for both documents, so it's about $400 each, okay, per document, basic fee. Some of you who have more complex estates, or some of you who have way too many assets to be just sitting there and require, let's say, a trust created in term, then, you know, depending on the complexity of what we have to draft out. But it starts about $400, so it doesn't break the bank, you know, and then we look at the complexity of what we need to add into your will. So.
Okay, and does the reality of being married versus common law make things more complicated when you're doing a will?
No.
Okay.
Well, no, but I always tell the common law people, because, you know, we're the province of Quebec is the champion province of people not getting married.
Right.
We're the first one up there in Canada. And I don't care, don't get married, but you better make sure your legal documents are on point, because if you pass away without a will and your common law gets nothing, zero, nothing. I don't care if you start crying and you try to go to the courts and you sobbing in my office, ain't nothing I can do. If you are not married and you do not have a will and you are a common law, your common law spouse gets zero, even if you've been with them for 30 years. Okay,
That's a really important point.
It's not recognized in Quebec. And so what would happen is, let's say you're common law and you have kids. Okay, whatever, goes to the kids. You can work around that. The worst is you're common law, you don't have kids, and then we have to announce to you that the estate is going to go to his parents and his siblings. That's fun times. So now that means that you become co-owner of your house with your in-laws. And what happens in estates, and what people forget a lot, is always, it's not just the legal aspect. It's all of, when it comes to money, people become funny. Okay? You may have the best relationship with your in-laws, but if you're no longer there and we have to talk about money, they're not going to be that nice to you.
Yes, so it can complicate. You know.
It's money. Money makes people do funny things, and grieving makes people react bizarrely. And so then you're kind of stuck in these dynamics. So you're grieving, you got to deal with your in-laws, you may have to sell your house. So, you know, the common laws, I always tell them, get your wills done, get your cohabitation agreement done, get your power of attorney done, get your stuff organized.
Okay, so here's a couple more questions.
Uh-oh.
If someone is making a will, do you have a portion in it that you can designate for your funeral services?
Absolutely. Mm-hmm. The thing about the will is we do include something about your funerals. Now, the best way to go about it is to have your executor know what it is that you want in terms of your funerals, because sometimes we don't find the will in time, or you've changed your will or stuff like that. So pre-planning is a great idea, and they give you a little card, you have that on you. But yeah, we can do whatever you want. The only thing I'm not allowed to write in the will is, we cannot say that I want my ashes spread on Lake St. Louis or on the promenade or whatever. I'm not allowed to do that. Okay, so it's still illegal. That's what you want? Don't tell me. I don't want to know. Tell your executor. So, but yeah, absolutely, that can definitely go in the will. A lot of things can go in the will, but nothing illegal. So we draw the line at.
Well, you touched on a really important point there, because you know, you can put it in the will, or you could go ahead and pre-plan it.
Yep.
And you know, the pre-planning is just another way that you know, show your gratitude to your family, because they don't have to be involved in that process. It's already organized. And that could be a wonderful gift. I know my father did that, and he sat down with me before he died, and he went through all his arrangements, and I knew everything. I had no decisions to make, and it really did make the process simpler.
You have no idea how complicated planning a funeral is until you show up at those funeral homes and you have like 62 kind of urns and 150 caskets, and you could be putting a necklace or in a little statue, and there's a lot of stuff going on. So pre-planning is, and we don't say like the whole thing, but at least, you know, where do I want to go? Do I want to be buried, cremated? Pick out your stuff, and that's enough.
Yeah.
It's a good idea. Very good idea.
All right, so I have one last question for you. Ready for it?
I'm ready.
Okay. How long does the whole process take if someone has a will and has passed, for all the paperwork to be done and all matters sorted?
As far as the legal standpoint, so for example, if you pass away on the 14th of the month, is a really bad time to pass away. So what happens is, once somebody's passed away, the first step before we can do anything is to do a will search. The will search gets done once we have a proof of death and a death certificate. So you're going to be waiting. We used to have to wait for the official death certificate from the government, but they're the worst right now. They're taking so much time that we now do it. We revert back to getting the proof of death from the funeral home. The will search can take anywhere from 2 weeks to a month, depending on what time of the period you passed away, because we have to file every 2 weeks. Every notary in Quebec has to file the wills that we did. We file that on the 16th and the 2nd of every month. So we got to wait for the period to close. So there's a good 3-4 weeks for the will search. Then in the meantime, we tell you, prepare your assets, etc. We can do any liquidation that you want, open the estate accounts, and that's not too complicated. What takes the longest is obtaining the clearance certificate from the government. Because once you've done all the taxes and everything's filed, you cannot be distributing assets from the estate until the government has reviewed the person's file and has sent you saying, okay, they've paid all their taxes, thank you very much, you may dispose of the assets from the estate. So a year, maybe a little bit longer.
Okay.
It's not very quick. These things take time, and it's not because, and I know a lot of people are rushed, and it's not your fault, is that you're dealing with banks, and you're dealing with investment companies and insurance companies and Revenue Quebec and Revenue Canada and the Notary and the Chambre des Notaires, so there's a lot of, you know, I wish it could be longer, but I always tell people it's going to take you a year. If it's quicker, good for you, but it's going to take you a year. And plus, you're not going to start liquidating the estate like, okay, they've passed away, thank you very much, here's all my paperwork. Like, usually people come and see us a good 3 weeks after the person's passed away, because they're grieving and they got to figure stuff out. So.
Well, Catherine, I've exceeded the hour that I promised you it would be.
It's okay.
By 5 minutes. I'm so incredibly grateful that you volunteered your time to come and be with us today.
It's my pleasure.
I'll tell everybody that if you want the contact information for Catherine, please let us know. We will happily send it to you. And because, you know, we believe in gratitude and we believe in giving back.
Good. Thank you for coming, everyone.
What we're going to do now is we're going to unmute everybody all at the same time. And we're just going to allow everybody to say their goodbyes and to just say thank you, Catherine. It was lovely speaking with you this
Thank you for having me.
afternoon.
Thank you.